The impact of divorce on a permanent resident permit in South Africa. A common question regarding South African immigration is, what happens to a permanent resident permit if a foreign national, who gained residency through marriage to a South African citizen, gets divorced? Under the Immigration Act of 2002, Section 26 specifically deals with permanent residence granted on the basis of marriage. According to the Act, permanent residence is issued if the foreign national has been married to a South African citizen or permanent resident for at least 5 years and the marriage is deemed genuine. However, this permit is subject to certain conditions. If the marriage ends within 2 years of receiving permanent residence, the permit may be revoked, except in the case of the spouse's death. To comply with these terms, the foreign national must present themselves for an interview at a Department of Home Affairs office within the last 6 months of the second year following the issuance of the permit, though in practice, this regulation is rarely enforced. Section 28 of the Act grants the Director General the authority to withdraw permanent residence if the holder fails to comply with the permit's conditions. If the marriage ends after the 2-year period, the foreign national generally retains their permanent residence and subsequent South African identity document. However, if the relationship ends within 2 years, either party may inform the Department of Home Affairs. Typically, it is the South African spouse who provides an affidavit to the department, detailing the breakdown of the marriage. The department may then summon the foreign national for an interview and, at the discretion of the Director General, decide whether to revoke the permanent residence. There are cases where permanent residence has not been withdrawn despite the end of the relationship, particularly when there are minor children involved who may benefit from the foreign parent remaining in South Africa.